need to, excuse me, push this onto YouTube. I usually don't do plea and arraignment on YouTube, but I should. It is a way for the public who could be in court, if they wanted to be in court, to see what's going on, hear what's going on, but they're not able to interact. So thank you, Ms. Rolak. We are now live on YouTube. Ms. Iovino, in order for you to enter a plea in your case, you have to be put under oath. Ms. Hall will do that in just a moment. I need to understand from you if you are willing to waive your right to be here in open court and instead proceed remotely like we're doing right now.
Yes, sir.
Okay. The other right that you are partially waiving is that in normal times, not only would you be here in court, but you would have Ms. Lewis sitting right next to you, so that if you had any questions or concerns, all you need to do is lean over and whisper in her ear. It's like, what is this judge doing? He's going crazy. And she could say, no, he's not. He's a good guy. Don't worry about it. You are waiving your rights to have your lawyer by your side if we go forward today. But we, through the powers of technology, can get you and Ms. Lewis into a private breakout room where you can see and hear her and vice versa. But I cannot, the prosecutor cannot. It really is like a private conference room. You guys disappear, and then when you're done, you pop back into this larger setting where we can all see and hear each other. So first of all, do you understand that you have the ability to have a private conversation with Ms. Lewis?
Yes, sir.
Okay. Do you need to talk to her yet, or are you good right now?
I'm good. Thank you.
Okay. And then finally, do you waive your right to have Ms. Lewis physically by your side during this plea?
Yes, sir.
Great. Then we can go forward, but do please let me and Ms. Lewis know if at any point during the conversation we're about to have, you want to have a private one-on-one. It really is as simple as I just sort of drag and drop with the mouse here, and boom, you guys are in a private room. So just let me know, okay?
Okay.
Thank you. You're very welcome. Ms. Hall, when you're ready.
Thank you. Good morning, Ms. Iovino. Can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
Melissa Sue Iovino.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 38 years old and I had completed up to 1 year of college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
I'm sorry, Your Honor. For the record, the state is no processing counts 1, 2, and 3 of the indictment. Those are burglary in the second degree, both counts, and enter an automobile or a motor vehicle with the intent to commit a theft or a felony.
Okay.
Ms. Iovino, do you understand that you've been charged with the following offenses? 3 counts of financial transaction card theft, 2 counts of financial transaction card fraud, and 2 counts of theft by taking misdemeanors?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Lewis, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes, I am.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We do.
Ms. Iovino, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum sentence for All 5 counts of financial transaction card theft and financial transaction card frauds are 1 to 3 years to serve, and the maximum for theft by taking misdemeanor is 12 months to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years probation for all the counts of financial transaction card theft and all the counts of financial transaction card fraud, and 12 months probation to run concurrent for theft by taking misdemeanor. Special condition that you complete the Apex program and any aftercare as directed.
Yes, ma'am.
But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those charges consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing or other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences to you as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of 3 counts of financial transaction card theft, 2 counts of financial transaction card fraud, and 2 counts of theft by taking misdemeanors in indictment number 19 SC 173950?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is unaware of any prior felony convictions by this defendant and had this case proceeded to trial. I know you're familiar with the facts, so I'll give a brief description, Your Honor. The state would have proved that on October the 16th, 2019, at 1155 Mount Vernon, Vernon Highway, Sandy Springs, Georgia, in Fulton County. Officers were dispatched to that location in reference to a larceny at the LA Fitness. After doing an investigation, they were able to discover that husband and wife defendants of this case went into the LA Fitness, purchased one-day passes, and during their time in the LA Fitness, they did go through both the men's and the women's locker room, taking car keys out of the women's locker room and a wallet and a phone out of the men's locker room. The keys that were taken out of the women's locker room by Miss Iovino was used to enter a vehicle in the parking lot, and a car and a charger was taken from that victim. There's no restitution being requested at this time for that particular victim. We have spoken with her. She did get anything that was used on that card refunded back to her. We did reach out to Chase, I believe is the bank, from the loss, and we have not heard back from them since the beginning of this case. So it is our, so there's no restitution that the state is requesting, and that the Miss Iovino was caught on surveillance at the LA Fitness, and that's how she was able to be identified, through purchasing the one-day passes with her ID. And that is all from the state, Your Honor.
Okay, and Ms. Hall, if I'm remembering correctly, there was a victim who did have some restitution. I think it was to the tune of about $130, but Mr. Iovino was going to be solely responsible for that, because there was sort of the men's room, women's room, locker room side of things. And so Mr. Iovino was responsible for Mr. Wolf, that's with 2 F's, gear. And so Mr. Iovino is paying that 130, and Mrs. Iovino is not responsible for that. Am I remembering correctly?
That is correct, Your Honor.
Okay, other question. You had alluded to the fact that it seemed like there had been more instances like this at, I don't think it was the same LA Fitness, but other gyms in the area. That's not before us now, but your point was simply that it did sound like there was evidence that the Iovinos, in an effort to support their drug habit, were engaging in this scheme, sort of bouncing from gym to gym.
That is correct, Your Honor. And I believe that other cases being handled in another county right now.
Got it. Okay. Thank you for that. Good morning, Ms. Crawford. How are you?
Good morning, Judge. I'm fine. How are you?
I'm okay. Do you have any criminal history from Georgia for Ms. Iovino?
No criminal history found for Ms. Iovino.
All right, thanks. So Ms. Lewis, is Ms. Iovino seeking to proceed as a first offender? Do you believe she's eligible, or are we not going there today?
She is eligible, Your Honor. That's not something that her and I had discussed. The reason being is there are 2 other cases open. So we have 2 other jurisdictions that we plan to potentially proceed with, which is why we had not discussed tackling that on this particular case.
What are the other jurisdictions?
So we have a case pending in DeKalb, and then we also have one in Cobb County.
Similar set of facts?
Almost exact, Your Honor.
Okay. All right. Well, why don't you tell me a little bit about Ms. Iovino and why you think this is the right outcome for her? Yes, Your Honor. So I will start by saying that Ms. Iovino is probably one of the most impressive clients that I've ever come in contact with. Since the first time I met with her, she was incredibly remorseful about some of the choices that she had made. She's been very forthcoming about her struggle with addiction, which led her into a very dark place. In 2019, up until that point, even at age 36, 37, she'd never been arrested. She has 0 criminal history. It seems that year was a downward spiral for her, both her and her spouse. As you were made aware of last week, due to their drug abuse, they essentially lost everything. Ms. Iovino was left without a home, without custody of her children, her health, her freedom, pretty much everything that she had to lose, she lost in 2019. She did spend about 120 days in county jails between DeKalb, Cobb, and then Fulton, where she was finally released. And then as soon as she was released from jail in Fulton County, she went directly into a treatment facility.
Not only was she participating there successfully, but she has such wonderful accolades from that facility that they have actually asked her to come on and participate potentially as a staff member. I believe that she's made impressive strides in a very short period of time, one that I don't necessarily see in every one of the cases I handle, such as hers. So I do believe that she's made incredible strides forward. I 100% believe that she's committed to her recovery, as that being a lifelong commitment, that she's dedicated to treatment, to being sober, to getting her family back, and being valuable not just to her family, but to other people who have been in similar situations to her. I don't believe that the facility would have asked her to come back and be a mentor if she had not had a hand in inspiring other people in her situation. So for all of those reasons, I do feel confident that she will recover from here. This was just a very difficult time period that she's moving on from. And I do believe that she's learned valuable lessons from everything that she's gone through. I believe today marks 243 days sober. Is that correct? Yeah. So for all of those reasons, Judge, we would ask that you allow her to proceed under the state's recommendation.
Okay. So Ms. Iovino, I've got a couple questions for you, and then if there's anything you want to add, I'm happy to hear from you. Before I do that, Ms. Rolak, was there anyone on your end of the line who wanted to be heard? Ms. Hall, do you know?
Your Honor, I know that Mr. Wolf is watching, but I don't think that he wants to give a statement or anything.
Okay, great. So Ms. Iovino, first of all, it does sound like you have made some impressive strides at confronting and dealing with the addiction. That is much of what was behind the real sharp turn you took in your life. Had you been working, like I said, I got to learn a lot about your husband, and he'd been a racer, and even before that in the cell tower business, et cetera. Had you been working, or what was your situation? I know you had kids, so you may have been perfectly busy with the kids.
Yes, sir. I mean, when my husband and we owned our own company, I was home a lot with the kids. I did come in and work with him and for him for a couple years, but that was just as, help needed. But I was definitely at home with the kids a lot. And then when we ended up having to close the doors on the company, then that's when I started working. And I was a project manager for a countertop company. So we installed countertops for residential and new commercial builds like apartments. So I was there for about 2.5 years, which was up until last September is when they let me go.
And your kids are with your folks or your husband's folks?
They're with my parents.
Okay. And is there a reunification plan in the works? I know you need to finish at Apex first, but how is that going?
Yeah, it's been great. Yeah, we do have unification paperwork. They do have temporary custody as of December 16th of last year. It does state in there that there is going to be unification, and my dad and my mom they know everything that's been going on. We tell them everything that happens as it happens. So they're aware. We were actually able to go see our children last weekend for the first time in 8 months, and it was hard to leave them.
I bet, but it's good that you could see them. So what was the drug, or were the drugs that you were struggling with the most?
Cocaine.
All right. And how much time remains for you in the Apex program?
I have 3 more months.
Is there
I'm 3 months behind my husband? So.
Okay. And why did you guys not start at the same time?
Because he was released from jail in January. I didn't get released until March 27th.
How is Apex being paid for?
I work. I'm a manager right now at Kroger, and they unofficially have told me that I'm being promoted again, because I started as just a clickless grocery shopper for online orders, and then I went to manager of my department, and now they're giving me another promotion, but it's not official just yet.
So you're paying for Apex because you're able to work while you're there?
Correct.
Okay. Is there an aftercare program?
Yeah, as my husband had told you last week, we're in the same position. I'm in the same position as him. So once we graduate, we don't have to leave. We're allowed to stay, and that's what we plan on doing.
Okay, great. How long is the aftercare program?
I know that the program is 9 to 12 months, but if the owner has said, Mr. Praveen said that if we needed to stay longer, we can stay as long as we need to.
Do you know how to spell his last name for the record? Nope. Okay, Parveen. We'll wing it.
Well, Praveen is his first name. That's Pravin.
Okay. Well, congratulations on so many days sobriety. I work in our drug court, and 243 is a big number. That is not easy to achieve, but of course, it's one day at a time, and each new day poses its challenges. So it sounds like you are very much living in the moment and thinking about how to get things squared away so you can get your kids back in your life, et cetera. Is there anything you want to tell me about the case or anything you want to add?
No, I think we pretty much have laid everything out there that we can.
Okay.
So, thank you.
All right. Yes,
Your Honor,
ma'am.
Would it be possible for me to actually speak with Ms. Iovina briefly? I want to revisit the first offender issue, if that's not a problem, just really quickly with her, just to make sure we're doing the right thing for her.
Sure, that is not a problem. So I'm going to move the two of you into a breakout room. I can't pull you out of it. You just, when you're done with the breakout room, there's some button on your screen you press and then you'll rejoin us.
Wonderful.
So let me see if I can make that. That's okay. Make that happen. All right, you should get a prompt on your screen. Click on that and you'll disappear for a little bit.
Yeah, I see.
There we go. Great.
Judge?
Yes, ma'am.
Okay. Jonathan Morrison, I know that it's 10:15. Sorry about the order of the calendar.
That's okay.
That case is probably going to be transferred to Judge Cox. I know that you had entered a bond order on Morrison, and he is still in jail as of the last time I checked because he has this pending case with Judge Cox. That's an 01 case. I was waiting for Ms. Womack to take it out of judicial hold. So I anticipate your case will be transferred to Judge Cox.
Great. No, I saw that note. Why do you say maybe? Why wouldn't it be 100% it's going to Judge Cox?
Well, I'm just waiting for the judicial hold to be lifted.
Okay. And what do we do if they don't lift the judicial hold?
Then we'll probably go ahead and transfer it. I was just being courteous.
Okay, I'm all for courtesy. That's great. I just wanted to make sure that if for whatever reason the decision was made, well, that's too old a case, I'm not going to lift the judicial hold. We could say that's fascinating, but you're still getting this case because it's a newer case with the same defendant.
No, that wasn't the case. I was just waiting.
Okay, great. So that would, Ms. Glenn and Mr. Morrison would go to Judge Cox.
Correct. So I'm not sure if that attorney is going to zoom in or not because it originally was put on our calendar to address the bond issue and also waive arraignment. But
okay, great. Yeah, I had made a note that it was going to Judge Cox, so I wasn't, maybe we'd see him, but if we didn't, I wasn't going to get alarmed by that. And that would just leave when we finish this plea, I guess we'd be back at 11, starting with Mr. Hillard.
Correct.
Okay, great. Thanks. You ready? Great. Okay, we are back on the record. Ms. Iovino and Ms. Lewis had some time in a private breakout room. Ms. Lewis, did you have enough time to speak with your client?
I did, Your Honor, and we are going to request to proceed under first offender if the state has no objection to that.
Okay. Ms. Hall, I'll cover with Ms. Iovino the pros and cons of first offender on the record. But before I go that far, do you have any opposition to Ms. Iovino being treated as a first offender in this case?
No, Your Honor, I don't.
Okay. Ms. Iovino, before I share with you the benefits, because it's mostly benefits, but also the risk of being sentenced as a first offender, I'm going to share with you something I'm confident Ms. Lewis did. But first offender, you get just one time, so there's no reason not to use it now. But if you end up, let's say is Cobb one of the places where you have charges? You
Yes,
go
sir.
in front of a judge in Cobb County. And Ms. Lewis, are you handling
I am.
Ms. Iovino's cases in those other jurisdictions?
Yes, Your Honor.
Okay. So let's say you get in front of the judge in Cobb. That could be the second nicest judge in the world, second to me. And she wouldn't be able to give you first offender, even though it's your first time in Cobb and your first time in front of that judge. You will have used it up on this case. And so I'm not in any way offering legal advice. The advantage that it seems to me is that if the way all this shakes out was that you were going to get a felony in each place, you'll only have 2 felonies instead of 3 by taking a first offender. But it could well be that other jurisdictions, because the conduct was maybe a little different, that they're willing to give you a diversionary sentence or who knows what. But I just need to preface my explanation of how first offender works by letting you know that you are using it up here insofar as it's not a drug charge. That the one caveat is there's a special first offender if all you're facing is a drug crime, and not a crime that was induced by drugs, but it would specifically have to be possession of cocaine, something like that. So if your charges in DeKalb and in Cobb are theft related or fraud related, you will have consumed or used up your first offender opportunity here. That's not a reason not to do it. I just want to make sure you're going in eyes wide open that when the dust settles and you resolve your 3 situations, you still may end up with a felony criminal history, even though you're getting first offender here. Do you understand that?
I do understand.
And understanding that, you still want to talk about first offender?
Yes, sir.
Okay. So here's the benefit of first offender. And I'm sure Ms. Lewis already told you, but that was not on the record. That was in private. We need to get it on the record. The benefit is that if I sentence you as a first offender, you are not a felon, and you will not be a felon during the duration of your sentence, provided that there aren't any hiccups while you're on there. There's not new charges or any basis for me to revoke your first offender status. First thing I'll tell you is that if you end up pleading guilty in those other 2 cases, that's not new conduct. That would not be a basis to revoke your probation or to touch your first offender status, because that is conduct that has already occurred. It would be you doing something you shouldn't do after today. That's the only basis for revoking your probation and, more importantly, revoking your first offender status. But as long as you are under sentence as a first offender, you are not a convicted felon. If you're looking for a job, you don't have to check the box that says I have a felony, because you don't. It is still a sentence, and you still will be reporting to probation, but you don't have a conviction. And if you successfully complete your sentence, then you can get it expunged, and it will be as if it was not on your record, which can have all sorts of benefits for school, for work, for other things. Now, all that being said, its benefit is somewhat diminished if you're going to follow it with a felony plea in DeKalb or Cobb. Again, not a reason to not do it, but it won't shield you from having a felony record if you then plead in either of those other cases. But you've told me you understand that. So the main benefit is it is effectively not on your record. You wouldn't need to disclose to anyone that you have a conviction, because you don't. The risk of first offender is that if you were to, let's say, relapse, this is all hypothetical, but let's say you relapsed and you went back to the ways of, I need to steal to support my addiction, and you got caught, you were in a car that wasn't yours, and you were charged with that. Those new charges could, they don't have to, but they could result in the revocation, not just of your probation, but of your first offender status. And losing that is significant in this way. Because you've already pled guilty, you could be resentenced up to the maximum in this case. You wouldn't get to have a trial because you've already said, I did these things. I went into the LA Fitness, I took these things, and I was wrong and I messed up. But without a trial, you'd have a hearing. The state would have to prove that you violated your probation, but it's a lower burden of proof. Assuming they did that, in theory, and I have to give you the worst case scenario so that you can say, I understand how bad it could get. If I add it all up, it's 15, 17 years. So in theory, you could be sentenced to serve 17 years in prison as a result of the charges to which you're entering a guilty plea today. So taking away first offender status, I resentence you as a convicted felon, and in theory, it could be up to the maximum. And I'll tell you now, to put your mind at ease, you'd have to have stolen a lot of cars and maybe run over some people with those stolen cars to be looking at 17 years. That would be, you did something real bad. But if you bust out of Apex, you don't finish it, you leave things behind, and that addiction gets a hold of you and you're getting in trouble again, people are going to think real hard about something that is a little more of a shock to the system than Apex. There is drug treatment that is custodial. And so it could well be that if you were to get new charges, not the Cobb case, not the DeKalb case, but a whole new case, that in revoking your first offender, I would say, you know what, I'm going to sentence you to 3 years in prison because I want to make sure you have time enough to complete the residential substance abuse treatment program that the Department of Corrections offers. The room does not look like that room. The windows don't open or anything like that. And I share that with you only as a cautionary tale. My hope is that what you've demonstrated to the whole wide world about your commitment to sobriety and your desire to reunite with your kids, that those are motivating forces that keep you heading in the right direction. But people are people and things can happen. And I need to make sure that you understand the risk of first offender as well, so that you are making an informed decision. Do you feel like you understand the benefit of a first offender plea, Ms. Iovino?
Yes, I understand.
You understand the downside or the risk of a first offender plea?
Yes, sir, I understand.
Understanding the pros and the cons, do you want to be sentenced as a first offender in this case?
Yes, sir.
Well, you certainly qualify. And in some ways, it's particularly tragic that you cross county lines in doing this stuff, because I don't have any influence in DeKalb or Cobb. Those are completely separate jurisdictions. This would be a great way to get you a fresh start with the first offender situation. But we'll see how things play out in those other counties. At least it's a fresh new start as of today and in Fulton County. Ms. Iovino, I'm going to accept your first offender plea. I find there's a factual basis to support the guilty pleas for counts 4 through 10 of the indictment. 1 through 3 are being dismissed by motion of the state. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we've talked about, either because you understood it right when someone said it, or because you had that opportunity to speak with Ms. Lewis about first offender. Is that a fair statement to say that your plea is knowing?
Yes, sir.
Voluntary means what it sounds like, that no one is forcing you to enter this plea, but you've decided of your own free will that entering a guilty plea is the right way forward for you. Is that true?
That is true.
Okay, then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Ms. Iovino, is that if while you are on probation in this case, you have a technical violation, which could mean you moved and you didn't tell probation that you moved, or you got behind in some fees, or you tested positive only once or twice for something. Those are things that I'm going to let probation and you work out. If it is a more serious violation, new charges, or you got kicked out of Apex, something like that, that would come to me and we would work through the situation. I'm going to follow the joint recommendation. I will sentence you on counts 4 through 8 to 3 years to serve. Those will be served on probation, and all those counts will run concurrently with each other. Your sentences as to counts 9 and 10 will be 12 months to serve on probation, and those will run concurrently with all the other counts. So it's a grand total of 3 years probation. A special condition of your probation is that you will complete the APEX program as well as its aftercare program. I'm also going to require while you're on probation that you stay out of LA Fitnesses. So if you're going to stay fit, you'll do it somewhere other than LA Fitness. But that's just something you're going to stay away from, and you'll be doing other things. As I mentioned, I am sentencing you as a first offender, so all the benefits of that status accrue to you. And I think the last thing I need to work through with you has to do with the indictment. If you were here in court, I'd actually get the indictment to you and you'd sign it, and your lawyer would sign it, and the prosecutor would sign it. But you are where you need to be. Ms. Lewis is where she is, and Ms. Hall is at her place. So I'm, with your permission, going to sign the indictment on your behalf. Do you authorize me to sign the indictment, Ms. Iovino?
Yes, sir.
Ms. Lewis?
Yes, Your Honor.
Ms. Hall?
Yes, Your Honor.
Great, then I'll sign the indictment for the three of you. I'll indicate on the indictment that the first three counts are being dismissed. And Ms. Nelson just reminded me to do that. I'll do that sitting on the printer back in my office. And we'll get that filed along with the final disposition. That's your sentence, Ms. Iovino. And you'll be good to go with Fulton County. The last thing that needs to happen, I'm going to let you do it here. I won't put you guys in a breakout room because our next case isn't going to be on until 11. So folks can go on to mute and whatnot, and I'll pop back on the screen a little bit before 11. But before you leave, Ms. Iovino, and you leave, Ms. Lewis, Ms. Crawford is going to tell you, Ms. Iovino, how you plug in with probation, because you will need to get to know them in the next 48 to 72 hours, I suspect. But Ms. Crawford will give you all that information, the address where you report, et cetera. Is your residence, Ms. Iovino, in Fulton County right now?
Yeah, it's in Roswell.
Okay, great. That makes things simpler. We can always transfer probation to another county, but since you're in Fulton, that'll keep it simple. Ms. Hall, do you have any questions or anything else in Ms. Iovino's case?
I do not, Your Honor.
Ms. Lewis, anything else?
No, Your Honor. That's all.
Ms. Iovino, I wish you the best. It is impressive what you've been able to do to turn the corner. I'm sorry that the shock to the system was as grave as it was. I think most of all, I hope that you and your children are together again. They need you in a clean and sober way. And I hope that soon you're able to see them for more than just a weekend at a time.
I appreciate that, Your Honor. Thank you so much.
You bet. Best of luck with everything. You guys talk with Ms. Crawford, and when she has gotten you squared away, Ms. Lewis, you're excused, and Ms. Iovino, you are free to go.
Thank you.
And I'll be back on a little before 11. Ms. Nelson, if we are starting earlier, if you'll just send one of those link things, I'll be at my desk, and that'll be notice that I need to come back.
Will do.
Thanks, everyone.
Thank you, Your Honor.
Good morning. I'm Ms. Crawford from probation. I'm going to need an address from you, and then I'm going to need a contact person, and then I will give you your reporting instructions.
The address that I have is 408 High Creek Trace, and that's in Roswell, Georgia, 30076.
Who will be your emergency contact?
My husband, Salvatore Iovino.
And what is his telephone number?
470-585-2375.
Do you have a contact number?
I do. It's 470-585-7793.
Okay, the reporting instructions that I'm going to give you, let me give you the address first. It's 276 Memorial Drive, Southwest, Atlanta, Georgia, 30303. The name of that building is Department of Community Supervision. And your report date will be July the 28th. That's on a Tuesday at 8 a.m. And that's 3 weeks from today.
Okay, I have it.
Okay. If you have any questions, I can give you my work cell phone. Like if you need the date changed, or if you think you're going to be late or something like that, I can give you a contact number. My name is Miss Crawford.
Okay.
And my telephone number is 470-303-6860.
Okay. Thank you.
You're welcome. Good luck. Thank you.
Thank you.
All right, thanks, Melissa. You did
Thank
great.
you.
I'll talk
Ms.
to you soon.
Iavino, this is the court reporter. Can I get you to spell your middle name, please?
S-U-E.
Thank you.
You're welcome.
So, you understand what you're saying with first offender? Like,
Means I can't get in trouble because if I do, I'm fucked.
no. What he's
It's from something new.
He's telling you the maximum.
Oh yeah,
Yeah, like
but that's
17
not
years. Like he
right.
said, you have to steal a whole lot of cars and run people over.
Right. I didn't want to laugh.
You know. So
Ms.
like,
Iavino, you might want to mute yourself.
Oh.
just go to the video.
You're excused. That y'all can go ahead and leave if you want.
Oh, here it is.
Excuse me? 11:30 on the calendar. DiMaggio Clance.
Yeah. He's outside.
He's outside. Interesting. I need to let the judge know because we're gonna have to have a
Yeah.
computer brought down here.
Hey, Carl,
Yes,
this is Deidre. It was a notice calendar and I'm not sure why they didn't set up a computer.
they did not, and the deputy just told me that our position number 8 is outside. In the
Okay,
lobby.
let me check with IT and find out what's going on. I don't get that because I thought I put in all my requests last week. Hold on. Let me
Okay,
look.
I'm not going anywhere. I'm staying in the courtroom.
Okay. Oh, Carl,
Yes.
I did put a request in last week for today is the 7th at 9:30. So
Okay.
whoever did it, they put it on hold.
Wonderful. You want me to contact Dejuan and see if we can get one down here?
Well, I sent another semantics report and then I will send him an email.
Okay.
Thank
Let
you
me know
so
if you need me
much.
to do anything.
Okay. Yeah, I didn't want to get caught too many times not doing it. So I think I went and put a bunch in. So Hey, this is Deidre.
Yes, Deidre.
Well, it looks like well, are you talking about the ticket that I just got? Okay. Originally, let me see who got the ticket. I think it went to, let me look right quick. See, I think that it might have been Lenora. Hold on. I'm trying to look for it. I just had it. Last week. It says it's on hold. If you go into looking at my, let me go into Samanage. Hold on. Okay, the one I put it in, let's see, it has ticket number 13166. No, wait, let's see. Oh, I'm sorry. Hold on. I'm sorry. Just a minute. No, I don't see it. Oh, okay, here it is. It's 13161. And it says it's on hold. It says George Bryant. That's who it says over to the right. Okay, thank you. Alrighty, bye-bye.
I'm unmuting. So we should be on position 6. It's a little after 11 by either clock in here. Mr. Hillard had Ms. Jernigan at first appearance, which says to me, public defender. Ms. Hall, do you know anything about Mr. Hillard's case?
Yes, Your Honor, that's Mr. Franklin's case.
Okay.
All 3 of these are Mr. Franklin's cases.
Well, all right. His third client is, oh, there's Mr. Franklin. Speak of the lawyer. He's coming in. All right. And here comes the hybrid system. With lawyer comes our ability to patch the folks in court to Zoom. So we'll sit tight for a minute and see what happens. Good morning, Mr. Franklin.
Based on what I was able to do research-wise on today's calendar, Martin Hilliard, he was listed, I guess, as a wrong case, but he's actually in custody.
Okay.
So I believe he's 6.
He's not showing, I'm not doubting you. I'm just looking, you think he's at Rice Street? Okay. Ms. Nelson, can you, under a different name or on these charges?
On his name.
On these charges? Terroristic threats?
No, not on these charges.
Okay.
So he had a misdemeanor of some kind, I believe that's my take. He received a sentence for that. And now unless he had a hold to a different county, so unless the hold picked him up yesterday.
Okay.
But he was physically in custody yesterday.
Yesterday. Okay. Let me see. I can try out the jail manager. Find a party. So Hillard. Of course, there are like 800 of them.
So that's an indication. If it pulls up all of them, then that's an indication that he probably is no longer in custody, unless you have to. If you go back, if it says show all jailings, it'll show every time someone with that name is arrested.
Okay.
But
so find a jailing, I would need his booking number, but I don't have that
you might
here.
step up and take a look.
No, that's fine. So if I go back to find a party or don't do find a party?
No, not find a party. Go to.
Yeah. You're fired.
Find jailing and click off of some of these so it's just a criminal defendant. Yeah.
Okay, and then do find a party?
Yeah, you find
Okay.
that.
I mean, it came up with some, but none of them had the. Looks like it's all the same guy.
Go back one more time and just do find a jailing.
Okay. Find a jailing.
Yeah.
And then try it, but by this?
Yes.
Okay, so he's out.
He just got to leave.
Okay.
So if you do it now, you go back one more time, just hit find. And click this box, include release jailings. That should bring up.
Oh, okay.
And if we find, it should be a 20.
Terroristic threats. That's what he's on for.
So he was released in one day on that.
Well, but that's from, is it from 2017?
Yes.
Okay, so then he was in more recently.
Correct.
For something else. I don't think it has any more pages.
He has a 20, do you want to know the new case number?
Yeah, oh, he has a new case?
Yes.
What's
Well,
that?
No, maybe that's not. No, it's not. It's the same case that we have.
Okay. All right. Well, my foray to jail center wasn't great. I gotta mute me.
I didn't write that book number, but he was like 4 notes. 213.
Okay, and your understanding was that another jurisdiction might be, I don't, do you ever look at, I don't need, do you need to see what, we're good, thanks.
All right.
Can't really, so it's a terroristic threat from almost 3 years ago that just got indicted. Okay. We may be moving terroristic threats to non-complex.
You know, I always thought there was a better place for that.
For a standalone terroristic threats, it's usually either an argument that got overcharged or someone needs to go to BHTC. Otherwise, terroristic threats comes with, you shot someone and this, and that case is already not going on. But all by itself, I think that's not complex. We're revising the list of charges to make it woven in there. We'll see.
I was in standard when we had standard.
Oh, back in the day.
Yeah, I was in the fight.
Okay. All right. So Ms. Nelson, I guess we'll need to do a little homework on Mr. Hillard. I don't know that a bench warrant is the right thing. Hold on one sec. Mr. Hillard is here?
Yes, Your Honor.
Oh,
He's outside.
okay. I thought Mr. Klontz was outside.
Yeah, Mr. Hillard just got it like
Oh,
30 seconds.
holy smokes.
Yeah.
Notice counting.
I'm out. Do you have to stay here just in case the system blows up, or you're making sure?
Since I just set up, I just want to make sure it works.
It works. Okay, that's good. Well, we'll have, when Mr. Franklin comes back, we'll have him say a few things and see if everyone else can hear him.
All right, sounds good.
Is it Mr. Hillard?
It's Mr. Hilliard, but it's not the guy that I looked up. So I looked up something wrong. So he wasn't in custody as of yesterday. So I was I was incorrect.
All right. Is he coming in?
I was going to check and make sure it was appropriate to do so right now.
Oh, yeah.
Yeah.
So actually, the courtroom is meant to be open as long as people are sitting far apart. If Mr. Klontz wants to sit over there and Mr. Hillard, we're not trying to sequence folks in any particular way as long as there is sufficient space.
Okay.
So if you prefer to have one at the table, that's great, but we have enough room in here and we've intentionally broken this out in 15-minute segments that if someone comes in early, he or she can just take a seat far from the other person. All right, Mr. Franklin, if you wouldn't mind, we're going to test out the sound system. If you could, from the podium, just say a couple things and we'll see if Ms. Hall can hear you. That'll be a good test.
A couple things.
Were you able to hear Mr. Franklin's Shakespearean rendition of my line, Ms. Hall?
Yes, Your Honor.
Great. We couldn't hear you. Can you say that again?
Yes, Your Honor.
Okay, now you're not on mute, but what, I have to have mine on mute. But I was not able to hear Ms. Hall. So should I unmute? But if,
Okay, let's make sure this is all the way up.
you need an extra pen?
That's feedback.
Should we try again?
Yes, have to try again.
Ms. Hall, could you say something else?
Sure. Yes, I can hear y'all. Nothing.
Try again.
I can hear you guys. Can y'all hear me?
Yeah, we can hear it now.
Okay.
So the problem is that was coming in through my computer.
Okay, yeah, because you initiated the call, right?
Right, but if I have my speaker, I just turn my speaker off. If I have my speaker on, we get all that weird feedback.
Can't remember, last time was it initiated from this laptop? And then,
This could not have been initiated from that laptop because you brought it in after the call started.
no, I'm talking about previously on your.
Yeah, I don't think so.
Initiated, okay.
Yeah, and I did not initiate the call. It was already going when I came in.
I think if I turn this one up, I get.
Sorry, Mr. Hillard, we're just working through a couple of technical things.
Testing, 1, 2, 3. So does it sound good from here? Oh. Testing, 1, 2, 3.
So we're good, but if Ms. Hall, can you say something again?
Yes, I'm here. Can y'all hear me?
Yeah, somebody else to try and speak and see if it's just her.
Ms. Nelson, could you say something, please?
Good morning, everyone.
Thank you.
Can you hear me?
So she said something, but it's.
Yes.
Good morning. I can hear everybody fine.
Me too. Ms. Nelson, can you hear me?
Yeah, I can hear you well. Let me tell them.
I'm hearing them now. It's not you guys, Ms. Hall and Ms. Nelson. It's something going on in court. Trust me.
Okay. Okay.
When I turn my speaker on, I can hear you very well, but then we get weird feedback in court.
So it's like when this is plugged in, it's when. Can we try it without this for a second?
Sure.
Testing.
All right, Ms. Hall, one more time.
I'm here. Can y'all hear me?
That's not your usual sound though, is it?
No, it's like it's coming out of just that laptop.
Yeah.
When it's working, I don't know that it necessarily comes through the speakers, but the folks on Zoom were able to hear real well. In fact, the issue has only been people on Zoom hearing people who were talking in court. And as a fallback, I can just toggle my speaker on and off. And so if I'm going to be talking, I'll turn the speaker off. And when we need to hear them, I'll turn the speaker on.
Okay. Let me just check the Zoom settings on here. Okay, one more time, Judge. Can you ask her to?
Sure.
Yeah,
Ms. Hall, will you give us one more?
I'm here. Can you guys hear me? I really don't know what else to say.
Yeah, it's still low.
All right, well, why don't, whoa.
That was pretty loud.
Oh, see,
Okay.
Ms. Hall was much clearer then.
Okay, I turned the speaker up on here, it was louder. Trying to balance it so you won't get feedback. Can you say one more thing for me, Ms. Hall? Is
Sure. What do you want me to say?
that better?
I think that'll work.
I think if I turn it up, it's still a little bit, so.
All right, we'll need to figure out what the deal is because
Okay.
they're getting weird feedback when I talk.
Yeah, you sound really weird.
In fact, let's not do it that way. Let's do it where I control it with the speaker here.
Okay,
And then you guys can figure out next time how it used to work.
right, okay,
All right, so let me try that.
all right.
Okay, so Ms. Hall, you can hear me now?
I can.
All right. So everyone bear with us. We're wrestling with the technology here, but we're going to move to position 6, which is 20 SC 174970. It's State versus Marvin Hillard. Mr. Hillard is here with his lawyer, Mr. Franklin, and we're on for a plea and arraignment calendar. Mr. Franklin, is Mr. Hillard going to waive arraignment?
Yes, sir.
You're filling out the waiver form. We're getting a good address for Mr. Hillard, things like that.
Yes, sir. I filled out the waiver of arraignment and the entry of appearance. Additionally, I've just filled out a change of address form. He did not receive notice directly. He received a notice from the apartment company.
Okay,
So making sure we actually can get the records.
got it. Ms. Hall, is this a case that needs a longer than usual period for discovery, or based on my understanding of the charges, it would be pretty quick turnaround in a COVID era for discovery?
No, it's not. But this case is pretty much worked out, Your Honor. So I don't think there's a discovery issue. I think it's more so Mr. Franklin just needs to discuss things with his client.
Okay, well,
So
I'll get that input from Mr. Franklin.
what I can say, so before I met Mr. Hilliard, just looking at the file, I looked up someone who I thought was actually in custody and was serving time already. And I relayed the information to Ms. Hall in anticipation of trying to figure out what an offer could be. Turns out that my Mr. Hilliard is not Mr. Hilliard I looked up. He was never in custody. Additionally, just my brief conversation with him this morning, I learned that he has no interest in pleading out to the charges. So we'll have conversations, I'm sure, but as of now, in speaking with Mr. Hilliard, this is one that we may look at trial for.
Okay, well, we will take it one step at a time. You have a bond, Mr. Is it Hillard or Hilliard?
Hilliard.
There's an I, two eyes?
There is 2 eyes.
Okay, so the system is missing your second eye.
You're definitely correct on that.
All right, so Mr. Hilliard, you do have a bond. You've had a bond since 2017. It's almost 3 years old. The main condition of your bond is that you stay away from, is it Ms. Hill or Mr. Hill?
Ms. Hill.
Ms. Hill. You're to have no contact with Ms. Hill. Lots can change over 2 years and 9 months. Are you and Ms. Hill maintaining separation, or are you back together, or?
No, we're not back together.
Okay, so continuing to have no contact with Ms. Hill should not be a problem for you.
No, not at all.
Okay, great. That's the main thing you need to be watching out for. I suspect the state would have heard about it from Ms. Hill if you had been up in her business.
Yes.
When you shouldn't be. But if almost 3 years have passed and you're doing your own thing and she's doing hers, I guess as you would only cross paths coincidentally. Should that happen, you just need to stay away. You walk into a Kroger and she's there, go to a different Kroger.
I have one more.
Yeah, we would actually want modification to the bond. They have children together. He does still provide for them. I prefer that conversation with her. You can have a no body contact provision as opposed to the all out no contact.
So you, Mr. Franklin, have had contact with Ms. Hill? Okay. And Mr. Hilliard wants to, should have this limited contact with Ms. Hill so that they can exchange the kids, et cetera.
I think that's the most they would have in terms of if they happen to be at a parking lot and drop off kids, that's the nature of the contact.
How old are the kids that you share with Ms. Hill?
My daughter, one is 6, another is 8, another is going to be 14, another that's going to be 16.
The two, you and Ms. Hill have all those kids together?
Yeah, 5 total.
Okay. And is she primarily responsible for them now?
Yes, but.
Do you pay child support?
No, I just take care of the kids.
Okay. But there's not a formal legal agreement that requires you to pay $408 a month or anything like that? Okay. How is she taking care of all those kids?
She works, and then I like I said, I take care of them also.
Okay. So you actually do then interact with Ms. Hill?
Just on the phone, maybe, like the kid needs paint, they need stuff, I send them payments, or I get whatever they need,
Do you work?
Yes.
What do you do?
I'm actually, I'm self-employed. I'm a property developer.
Okay. And you're doing that now?
Yes, that's correct.
Okay. All right.
Your Honor. I know
So
we're
what
not,
you are asking for, Mr. Franklin, is a bond modification that would allow Mr. Hilliard to have nonviolent contact or non-tumultuous contact with Ms. Hill, but solely for the purposes of taking care of the kids.
Correct, sir.
Okay. Ms. Hall, have you been able to hear what we've been talking about?
yes, I can hear you all.
Oops, I need to unmute you. Hold on, my bad. Have you been able to hear what we've been talking about?
Yes, Your Honor, I could hear you. I could hear everything. I was actually trying to interrupt at one point. I wanted to see, oh, okay, never mind. But yes, I can hear you all.
Ms. Rolak, is Ms. Hill on the line with you?
No, Judge, she is not. I've spoken to her yesterday.
Do you have any input from Ms. Hill about this situation?
Judge, she has not been forthcoming with information to me. I just know that she does not want to pursue the case.
Can you or Ms. Hall please reach out to Ms. Hill and get her sense? It sounds like she will not object, but technically she and Mr. Hilliard have been violating the bond over the last 2.5 years, but in a way where they were actually helping out their kids. I'd like to fix that. But the right thing to do is to at least hear from Ms. Hill as to whether she has any objection to modifying the bond so that she and Mr. Hilliard can have contact for purposes of caring for their children.
I will call her right away, Judge.
Thanks. And if you're not able to reach her while we're on this calendar, you can just send an email to Mr. Franklin, Ms. Hall, and Ms. Nelson, letting the three of them know what Ms. Hill's perspective is. I'm cautiously optimistic that she'll say, that's fine, you can modify the bonds. That's how she's been living her life the last couple of years. But we ought to get it right on paper so that Mr. Hilliard doesn't get caught in a trick box if suddenly someone gets frustrated and says, look, he violated the bond.
I will do so, Judge.
Thank you so much. Ms. Hall, anything else on Mr. Hilliard's case?
No, Your Honor, but you did ask me originally. I did. Me and Mr. Franklin was on the same page yesterday, but now understanding the information being different, I will need to get that discovery to him. And that is from Fulton County Police Department. It's not APD, but I don't think it'll take that long of a turnaround.
Okay, well, if you could start looking into that, I know it's an older case, but it doesn't sound like there are a lot of moving parts. And I think you're able to hear Mr. Franklin. He had identified a different Marvin Hilliard for whom whatever you all had been negotiating may have seemed like a reasonable disposition, but the actual guy views things differently, which he's of course entitled to do.
One thing, in terms of what Ms. Hall gives me, I do have, there was a certificate of discovery filed in March of this year. I have a copy of that. So aside from maybe 911 call or something, nothing else jumped out to me. And it's not a physical violence case, it's nothing, no medical reports or anything. So maybe 911 call, potentially by him, again, it's set 2017. And I don't think they were required to be like at that point in time. So.
Were you able to hear what Mr. Franklin said, Ms. Hall?
No, Your Honor.
So apologies again about the sound system. Mr. Franklin already has, he showed it to me, the initial discovery packet, which is the police report and whatnot. And in his review of that, his sense is that at most what you might find when you reach out to Fulton County PD is a 911 call. Mr. Franklin doesn't think that body cams were in play, especially for that agency back in September of 2017. So Mr. Franklin said he feels like he's got virtually everything unless there's a 911 call. There aren't going to be medical records in this case. It wasn't that type of interaction between Mr. Hilliard and Ms. Hill. So my hope is the two of you can start talking about other approaches to the case. It sounds like Ms. Hill has developed her perspective on it, but obviously the state needs to decide what the state thinks is right. But we'll get a scheduling order entered that will give you a little time to try to get with Fulton County PD to see if there is anything else. And we'll wait to hear back from Ms. Rolak about modifying the bond, meaning Ms. Hill's perspective on modifying the bond. And then I will address that. Ms. Hall, anything else you want to cover in Mr. Hilliard's case?
Nothing else from the state, Your Honor.
Mr. Franklin, anything else? Okay. So Mr. Hilliard, appreciate you making it down here. Your new address or your current address will get into the system now because of the paperwork you signed. You should get notice in the mail for when you would be coming back down here. My guess is that your next date to come back down here would be a date to see if there is a way to resolve the case short of trial, whatever that might look like. And there are lots of options, many of which don't involve you into anything other than, yeah, we got into a shouting match and there's not a conviction, but you and your lawyer will sort through that. And if that's not how it plays out, then you'll just go on the long line of cases waiting for a jury. All right?
Yeah, I appreciate it.
You bet. Thank you for coming down here. Ms. Rolak, do you have an update?
Yes, Judge. I was just able to speak with Ms. Hill. She says she wants contact. She says they have been having contact and she wants to continue to have contact.
Got it. So I think you could hear that.
It sounds that she wants contact.
She's happy to have contact. She wants contact. So hopefully everyone's processing that response. But I will modify the bond. I think based on how Mr. Hilliard described it, I'll still keep it while these charges are pending, confined to contact that relates to taking care of the kids. So you two can't go out to dinner. But if you need to connect because you're bringing over something for the kids, or you're picking the kids up, that will all be okay by the new bond. Thank you.
Your
All
Honor.
right. Thank you, Ms. Rolak, for that quick turnaround.
Thank
Your
you,
Honor.
Judge.
Your Honor, can you hear me?
Yes, ma'am.
The state is no cross in that case.
Oh, okay. Thank you.
You're welcome.
So hold on. Ms. Hall just announced that the state is null processing the case. So early Christmas for you. They dismissed the charges.
It's my birthday.
All right. I have to stamp the indictment and do some things, and you may want to get a copy of that from Mr. Franklin, so make sure you've got his phone number. But it means I don't get to see you again. You do not need to come back.
I'm good.
You're good. All right. Well, I will not modify the bond, and I will thank Ms. Hall for that on-the-spot processing of what's going on here. Hopefully, if you and Ms. Hill have disagreements over the many kids you've got, you work them out in a way that doesn't cause someone to be concerned for their safety.
Thank you.
All right.
Appreciate it.
Take care.
God bless you.
Is Ms. Hughes coming in or dialing in, or what do you know about Ms. Hughes?
I don't have any information on Ms. Hughes. It's a direct indictment. I don't have a file or anything that would have had a basic contact number to begin with. So she may or may not have received notice in the mail. It depends on, I guess, if her address is current or that kind of thing.
I'm looking her case up. See how old the allegations are. Very recent. Okay. So
She got notice at her last hearing, which the address shows 1328 Peachtree Street Northeast.
okay. So Ms. Hall, what Mr. Franklin was saying, and I turned the speaker on so that maybe you could hear him, but it's a direct indictment. So Mr. Franklin has not met Ms. Hughes. But unlike some of the direct indictments we see, it was very close in time. The incident's from January, and the indictment was soon thereafter. So information should be relatively fresh. And it sounds like notice was served based on all the information that was gathered from not all that long ago. Do you have any information, Ms. Hall, about the case?
What do you mean about the case? Like as far as discovery? More.
Well, I didn't ask that very well. It's a direct indictment, and it looks like Ms. Hughes got notice. I don't know if you've been in touch with the victim through Ms. Rolak, or it's a family violence aggravated assault. So I just wasn't sure if your side, your team, was aware that, yeah, Ms. Hughes, she actually moved to Texas because she broke up with whoever the significant other was, or anything like that. That's all I was asking.
Okay, I'm sorry, Your Honor. No, Your Honor, I don't have any additional information.
Hold on one second, I can't.
Oh,
okay. Go.
I'm sorry. No, I don't have any additional information. We've been trying to contact our victim and we have been unsuccessful so far. So we don't even have, the firsthand knowledge of the case other than the police report.
Got it. So Ms. Nelson tells me that there is already a, let's see exactly what she said. There is an active warrant, so we'll just move this to judicial hold. And if and when Ms. Hughes crosses our path, we will pick up plea and arraignment then. Is that why there's a W, Ms. Nelson? I'm noticing
Yes.
In the calendar, there's the 7, and then below it, there is a W. Is that your secret code for warrant?
That is not my secret code, but that is picking up from Odyssey.
Go Odyssey. All right. Thank you. So that's what we'll do there. Warrant and judicial hold. Which brings us to position 8, last but not least, Mr. Klotz, who I believe is here.
He is already in the office.
Okay. You ready, Mr. Franklin?
Yes, Your Honor.
Ms. Hall, are you able to hear? I'm trying a different approach with speakers here. There are a lot of feedback.
No, you just sound, I can hear you clear. You just sound like you're a little far away.
Okay.
No, like, sound like you're in a room with no furniture. That's what you sound like.
Okay. And can you hear Mr. Franklin?
Hello, hello, hello.
Yes, I can hear him.
All right, we'll do that for now.
Okay.
So our final position is State versus Mr. Klontz. Hello, Mr. Klontz. Turn this off for a minute. I'm Judge McBurney. I'm handling your case. You have been indicted for a few charges that relate to something that allegedly happened involving a machete. Your lawyer, Mr. Franklin, is sitting there with you, and today I need to find out through Mr. Franklin if you are waiving your arraignment or if instead you want me to read into the record all the charges that you face. And then we'll talk a little bit about what the next step is for your case, okay? Mr. Franklin, have you had a chance to talk with Mr. Klontz about whether he's waiving arraignment or wants to be formally arraigned?
Yes, Your Honor, we will waive formal arraignment.
Okay. Mr. Franklin has announced that Mr. Klontz is waiving formal arraignment. I see Mr. Franklin is filling out the magic paperwork that will do the entry of appearance and get us a good address for Mr. Klontz. Ms. Hall, is this a case where discovery is close to ready, or what do you need in terms of a scheduling order?
Well, this is another case that I believe once Mr. Franklin speaks with his client, it's probably worked out. So I don't need anything. If Mr. Franklin still requests anything from me, then I'm sure he'll tell you. But I think that we're almost at a resolution for this case.
I think that's an accurate representation, Your Honor.
You think that is accurate?
Yes. So I attempted to call Mr. Klontz before today's court date, but the phone numbers that I had in the police report weren't valid. So we weren't able to talk beforehand. However, in our brief conversation now, he has indicated that he would like to try to work this out. And we have it's not track one anymore. We have a recommendation from the state on the conversionary track for behavioral health court. I just need to make sure that there are certain things that are in place and get moved in and processing that. So I think we have a plan. I need to see if Mr. Klontz is in agreement with that. But being able to keep something off his record, I think we may be able to reach that resolution.
Do we need to do a referral to BHTC?
We will. I need to speak to him first to make sure I can give him a very general explanation of what the program is. His caregiver is here as well, so I want to make sure that he understands what's going on. So probably by the end of the day, I would be, if it's going to go that route, I will have to refer to that.
So in terms of next steps, it sounds like Ms. Hall doesn't need to be doing a whole lot on the discovery side. We'll be hearing back from you, Mr. Franklin, about what may make the most sense for Mr. Klontz. And if folks are aligned that a diversionary track in BHTC makes sense, then we just have to make sure that the intake work is being done.
Correct.
So for Ms. Nelson's purposes, because she needs to track the case, she'll enter a scheduling order. We just do that as a matter of course, but really she ought to be hearing from the lawyers sooner rather than by some deadline in the scheduling order that the case is ready to get into BHTC.
Correct. The only holdup will be just kind of speed. If we come to an agreement with what we have already, the only holdup will be the ability for BHTC to move fast or slow, anything like that.
Sure.
But
Okay.
again, once we discuss everything again.
Okay. Mr. Klontz, it sounds like your lawyer has been doing some good thinking about your case. He needs to talk with the prosecutor who is on this call. And then we'll wait to hear what all you may be ready to do in terms of getting into a program that we've got that's meant to help out, okay?
Yes, sir.
Your Honor, do you actually have a physical file with you? I'm going to check and make sure the address that was
No, but I can tell you what's in Odyssey.
Yeah, I want to make sure that the address that the acknowledges.
So I've got an address of 256 Fairburn Road.
You know, he doesn't live there anymore. He has to stay with me, so the address is changed.
Great. Well, thank you, one, for taking care of him and giving him a place to be. But number two, we'll get Mr. Franklin to fill out a change of address form. You can give that info to him, and that way the notices will get to your joint address. But it sounds like you'd be in a good position to help. Is Mr. Klontz related to you? Your uncle? It'll help you help your uncle process what's coming in, because we may need to have him come back to court sometime soon to talk about what we're going to do. Did you at one time, Mr. Klontz, live on Fairburn Road?
Wow. My sister passed, I had to move.
Okay, but your sister lived on Fairburn Road?
Yeah.
Okay,
She did see
okay. Ms. Rolak, is there anything from your side in terms of victim in this case?
Judge, I guess my only concern would be that that address that he gave just now, the Fairburn Road address, is where the juvenile victims live.
So the Fairburn Road address, which is what's in the system, is no longer where Mr. Klontz lives. His sister lived there. His sister passed away. And when she passed away, then Mr. Klontz had to move. He now lives with his nephew. We're getting that address, but that's not on Fairburn Road.
Okay. So I spoke with the niece, which is the mother of the juvenile victims.
I'm sorry, I was slow in shifting out of this annoying mute situation. Can you repeat what you said?
I spoke with the Miss Kakina Harris, which is the niece of the defendant of Mr. Klontz. And she is the mother of the 3 juvenile victims, I believe, yes. So they live at the Fairburn address, and indeed the grandmother passed away.
Okay. So what is the new address?
The nephew filling out. 847 Everly Court, Lithia Springs, Georgia.
So it's a zillion miles away from Fairburn Road.
Yes.
Okay. All right. So Ms. Rolak, I appreciate you flagging this, but Mr. Klontz now lives in Lithia Springs.
Okay. And the Miss Kakina Harris, she does not want to pursue charges. She did talk about the mental health issues as well.
Okay. Well, it sounds like Ms. Hall is helping Mr. Franklin line up a diversionary track that would be consistent with what everyone is talking about, which is getting Mr. Klontz some help so that we could avoid another situation like the one this is alleged to have been. And hopefully, Ms. Harris, the person you've been talking to, knows that Mr. Klontz is living in Lithia Springs, but maybe the family isn't communicating in that way. But you can let her know if she doesn't, not the specific address, but that he's residing far from the Fairburn Road address.
I believe she is aware. She did know that her brother, who is there with the defendant, was coming to the hearing today.
Okay, that's what I thought, and her brother has confirmed that the family is aware and that this is a safer setup to have Mr. Klontz out at the Lithia Springs address, which I have here. So we've got the address change form and the waiver of arraignment, and think we are all set. Ms. Nelson, do you need any other paperwork from Mr. Franklin at this time?
No, I do not. As soon as Mr. Franklin fills out the referral, that's all signed. If he just can scan it to me, that's fine. I can email it, e-file it, or whatever Mr. Franklin wants to do.
Okay. Ms. Hall, do you have anything else in Mr. Klantz's case?
Nothing further from the state, Your Honor.
Great. Well, thank you, everyone. Mr. Franklin, do you have the revised referral form for accountability?
I just grabbed one over there, so it says the card and all that.
That's a bad one. I'm going to print out some and put them out there, but please let me get you one before you go. I'll go back to my office and do that. We are trying to use the new form now, which is now the only form on Odyssey, because these have been, wow, it's a lot of trees. Okay, I'll recycle these. Great. So I'll take care of that. Ms. Nelson, what do I do with the waiver of arraignment and the address change form? Do I scan them and send them to you?
Sorry, can you hear me? Oh.
Yes.
You can either do that or you can leave them for Michelle to scan and she can do that.
Okay, we'll sort that out offline.
Okay.
All right, I think that is everything. Thank you, Ms. Hall, for your work today. Thank you, Ms. Rolak, for having people lined up who needed to share their perspective. Ms. Crawford, you got to tell one person at least how to get to probation, so some productivity. This is Henry's final week as an intern. So Mr. Church may outlast Mr. Gao. I'm not sure how long Mr. Church is with the PDs.
Pretty much through August.
All right, so he'll outlast Mr. Gao, but the virtual internship that the Latin American Legal Foundation set up ends at the end of this week. So thank you, Henry, for being on board. You and I will talk later this week. I think that's it. Wait, where everyone goes, let me see what tomorrow holds. Tomorrow is the 8th. We have a calendar in the afternoon. So I will see or hear some of you all at 1 tomorrow afternoon.
Sorry, our jail calendar.
Say again?
It's our jail calendar.
Great.
So
persons will be zooming in from jail, correct?
Correct.
We will not have more inmates in the building until probably July 27th. We're working on what that rotation is going to look like. We have to weave in a bunch of, there are a bunch of folks sitting in jail who have CP cases that have not had prelims or even bond hearings. And so we're trying to prioritize that. Absolutely. While balancing my colleagues who are banging on the door saying, when can we have people brought over? Okay. So, but there'll be a rotation. And the way we're trying to structure it is that we'll have the same day every week for planning purposes. You all will know, I think will be a Tuesday, that every Tuesday we'll be bringing people over. And those calendars will be notice calendars in the sense that if it's a suppression hearing, they have to be issued far enough in advance that Ms. Hall can let the officers know you need to be here for the hearing, that kind of stuff. But we can do whatever we need to with the inmates who come over. It's not limited to suppression hearings. It could be arraignment, it could be whatever. We're limited to number of inmates that can come per judge, but not what the subject matter will be. So hopefully we'll be able to advance some cases, not necessarily resolve them, but at least advance them to now all that's left is trial, because we've dealt with the suppression hearing and we can do what we need to do. So we'll see how that plays out. So tomorrow is inmates, but the inmates will all be on Zoom.
Your Honor, I have a quick question.
All right, thank you, everyone.
Wait, Judge.
Oh, sorry.
Your Honor, I have a quick question about tomorrow's calendar. So it's a revocation. Well, it says special hearing, but I think majority are revocations. Are we going to handle it where we're just going to tell you whether we need a real revocation hearing to be scheduled? That's one question, and I have another question after you answer that.
Okay. So If it's the first time that the case is on a calendar for revocation, then if it's something you all can work out, let's work it out tomorrow. But if it's one where the defendant says, either I can't admit to that because the underlying thing, the allegation is he's killed someone. I'm not gonna admit to that in the revocation hearing because that could come back to get me in a worse way. Or the defendant simply says, no, I contest that. That's not what happened. Then we would have another date. So you are not expected, Ms. Hall, to have all the witnesses you need. Hopefully, you and Mr. Franklin and Ms. Patel and whoever else have been talking so that you've got a little sense of, yeah, this is one we probably can work out because the defendant will either admit to the allegations or stipulate that the state could prove it. Or sometimes you guys say, we're not going to pursue the more serious one, but they're admitting to technical violations and everyone agrees to 3 months. But if there's no meeting of the minds at all, then the question will be, all right, when do we bring everyone back? And does it need to be an in-person hearing? Because that's another way we'll be using the in-person calendars. If a defendant is saying, I want a hearing and I don't want it to be a Zoom hearing for that revocation. Does that answer that first question?
It did, Your Honor. And the second question, we have been talking, and one thing that's come up in conversation, for instance, position 3, 4, and 7, they all have new cases, and you know how most times we close them out together with the already indicted case and then revoke them at the same time. When they get indicted on the new case, they're gonna be assigned to a courtroom, and it may not be your courtroom. So the question has come up as, do we just wait to deal with these when they're indicted, send them to the courtroom where the cases are already being dealt with, or what? So for those three, that question may come up tomorrow, more so from the defense counsel, but that is something we've been discussing in the background.
Sure, and that's a topic that the judges have begun to hear more about. There are a number of approaches. One would be, it's interesting that they're new charges, but here's this revocation. And if the state can show by a preponderance that John Smith committed a new shoplifting while he was on probation for old shoplifting, we're going forward because the judge wants to, if the person did a new shoplifting, revoke on the old one. And the judge may not be interested in waiting. Another approach would be to just kick the can down the road, but the person's probably going to stay in jail. A third actually shifts the focus to the DA's office, assuming the defendant is comfortable with it. And I think once we move out of non-complex, we've got lawyers who on the defense side might be more comfortable with it, would be to agree to an accusation. And then if the line ADAs are empowered to accuse a case, then the notion would be to try to get that done in advance, or at least have the waiver of indictment happen in front of the judge while you're having the revocation hearing, and everyone gets on the record that the state will, in the next 3 days, accuse the shoplifting, and the judge is saying, great, assuming nothing changes in these next 3 days, you can plead to the accusation, and your sentence in that is going to be the same as what just happened in the revocation. And so we are pulling the CP into this division, even though it might not ultimately, as an SC case, come to this judge. A number of us are very comfortable resolving the unindicted charges if they can be accused, and the defense is okay with that, as a more efficient way of wrapping everything up for that defendant. So I hope we see more of that. That requires ADAs being authorized to accuse things, and it would require the defense attorney to say, I'm willing to move forward on that accusation, even though the discovery I have is limited to the police report. I think in a lot of cases, that's more than enough, but it won't be true in all cases. And then we'd have to take a different approach. That was a real long answer, but it was a way of letting you know that I think there are a number of approaches to help a defendant resolve everything in front of one judge, and it may not be just one setting, but it would be just a few days later, you're back with the accusation.
I got it. Thank you.
All right. Anything else, Ms. Hall?
No, that's it.
Okay. I know you're waiting on the referral form, which I'll go print.
No,
Is that it?
I was listening.
Okay. 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 Ms. Nelson, did you have anything else? I noticed you were not on mute.
No, I'm okay. Thank you.
Okay, glad to hear you're okay. All right, thank you, everyone. Have a good rest of your day. Bye-bye.